Thank you. So I will start by the typical lawyery thing to do with a disclaimer. So I'm unfortunately not a legal officer in this scenario. I'm dealing with this subject matter from an advocacy point of view mainly. And I will try today to give you the main frameworks, things that you have to consider as trainers, but these are not the details. And in your day-to-day research, it's good to have legal advice because, as Magdalena said, it depends on the situation. It also somewhat depends on the lawyer, to be honest, on how risk-averse the lawyer is or the researchers are in your department. So, but it's good to analyze the specific situation each time. So. When we are talking about the legal framework that applies to data, we have maybe three major spheres that we have to be aware of. First, data may constitute in some way intellectual property. If it's raw or processed data, it doesn't really matter because we could, as Milena mentioned, we could work with data that is already copyrighted in humanities, so it's not necessarily a data that is not subject to any rights that we are working with. When we are talking about data that is protected by some kind of intellectual property, this is considered as property, so we can license this data, we can sell not exactly this data, but you can imagine some kind of property over the data. The second sphere that we have to consider, this is personal data. It is protected by the data protection legislation, and it's protected in a completely different way to intellectual property. So here, with personal data, we cannot license it, we cannot sell it, so to speak. We just have to comply with the data protection legislation because the protection of personal data is based on the fundamental human right to privacy. So this is not something that data subjects can just sell or license or put in a contract, generally speaking, in any way. Then we have, relatively speaking, non-personal data. So this is data that is not protected in any way, not by personal data protection legislation, is not subject to intellectual property. There we also have legal frameworks that maybe that are focused on stimulating or even obliging scientists to open the data up. So here we have the open data legislation or the data management legislation. So it's a different type of legislation where usually when we have public funding, we would be motivated or obliged in some cases to share this data. So these are the three major frameworks that we have to be aware of. And I'm starting with the intellectual property framework. When we are talking about intellectual property, in research contexts, we are mainly thinking copyright and related rights and patents, patentability mainly. Copyright, this is something that arises automatically. So we don't have to register it anywhere. We don't have to patent the information on the work or the works, etc. Copyright arises over so-called works. In Bulgarian, it's произведения. So this can be text, images, software, and so on. And copyright arises automatically as long as we have a creative work, so it's original work, we have human creativity there, and this original work is put in some objective form. So we are not protecting ideas, general ideas, we are protecting specific objective manifestations of ideas like text, like images, etc. As long as we have, for instance, an image, and it's a creative image, it's created by a human, it's copyright protectable, okay? Yes, of course.
This original work, because it was exactly the case with this calibration of the machine. So one researcher argued with the other that the calibration, it was the origin of the work, because he was thinking about how to calibrate, how to use, and
it's a huge theme.
Okay.
Oh. Especially now with generative AI.
No, I
you
don't
can,
want to touch
I mean,
this.
when you have a yes, exactly. It's a huge theme. So.
So my prompt is better.
I would argue that this does not constitute as creative effort or creative control over the output, because it's something automatic. Mm-hmm. But it's
but the mathematician formulas, they are like
this
ideas,
is not
because they are not
formulas are not, I would argue, subject to copyright. Yeah. But software is, or I don't know, in the humanities, if you are working with text, with interviews, with images, these are subject to copyright. And also databases can be subject to copyright if they are creatively assembled. This means that if you had something that you haven't assembled yourself, it will be difficult to apply copyright to it. But otherwise, it can be. If it's original, if a database is original, it can be subject to copyright. And then you also have to account for the
question here, though.
Yeah.
My impression is that in the EU, algorithms are actually not copyrightable. So strictly speaking, algorithms...
In terms of functionality, no, they are not.
Exactly.
They are not, but this follows like the general principles, idea versus expression of this idea. So the algorithm, you would say the functionality is the idea and the code itself is the expression. So what you have protected is the code.
Yeah, and
as a text, I mean, it's not a human text, but it's human readable. I mean, it's a form of...
Essentially, if we do perform our research, right, using algorithms, right, would the code snippets be copyrightable?
Yes. If you, I mean, what do you mean by using algorithms? You use someone else's code, or you're just...
using data analysis, I have written 1,000 lines of code. Is this copyrightable?
Is your code copyrightable? Yes, it is. If you have achieved the same functionality, it doesn't matter, because what matters is the code. If you have used someone else's code, then it's a matter of, I don't know, authorized use, or you can use it under fair use rules, but yeah, it is.
Isn't this actually debatable? I was actually the startup, we did create a software product, right? So we got quite a bit of legal advice on IP, whether that's copyrightable or not. And that was very debatable. I mean, the consensus seemed that it would be copyrightable if it's connected to some sort of hardware component, but if it's software...
Sorry, you're talking about patentable?
Yeah, exactly.
Because this is a different thing. I'm going to talk about this software.
Yeah. For 20 years. Any line of code you write, it's your intellectual property. If I sit down right now and write a line of code, it's my intellectual, but I can patent it.
Yeah. In the European Union, it's prohibited to patent software as such.
Yeah, but the algorithm, if it's a new one, you can have an utility model on the algorithm itself. Mm-hmm. So it's...
It depends. It can also be patented in the US, and there are European companies that do patent software in the US. But if we start discussing this now, we are going nowhere with the presentation.
Yeah. Just let me make
Yeah.
So when we train our colleagues, what we're going to tell them, because we do a lot of data analytics at our faculty, including our research group and all that. So we're saying, okay guys, essentially you do have copyright on your code. You might have a useful model on it, but you can't really patent it. So
It depends. It depends.
Because obviously that's a question. We also have a lot of discussion. We have an Institute for Intellectual Property ourselves, right? So it's back and forth, and that's a question people will ask when we tell them, guys, we need to publish this.
Yeah, in this case, you have to consult with a patent lawyer or a patent expert. Specifically, I mean, it's not. It's fairly different subject matter from copyright. So, of course, there are ways to patent software, just not as such, but there are a lot of roundabout ways to patent software. So. Yeah, but for each specific case, you have to just consult with an expert.
Reason why, for example, EOS or European Commission and different groups, they are creating the software management plan. Because the software management plan, they are dealing with a little bit different, even if your software can be treated as the research data, they also try to, in the data management plan, they need to cover your doubts. And I will show you that a little bit later. It might be interesting from your point of view also.
Okay, so continuing with related rights. This is something typical for the European Union. We have so-called related rights in the EU. Also known as neighboring rights, if you've heard about this. These are specific rights that mimic copyright, but they're usually given by the legislator to investors in certain industry. For example, you have phonogram rights, you have film producers' rights, you have broadcasters' rights. These are like companies in certain industries that have rights over phonogram or over the first caption of the film and so on. In this case, we have a form of related rights over databases. So we have a 15-year-long right of the producer of databases. It's not called neighboring rights, it's called a sui generis right, but it's a kind of neighboring right. So over databases, potentially we have two forms of rights. If the database is original, we can have copyright over it. And if the database is subject to, substantial investment or something like this, then we can also have this related right over the database. We have to be aware. If we are using already prepared databases, we have to be aware that we might have to clear two types of rights over the database.
Can I ask a terminological question here? So the database rights are somehow arranged, but we discuss a lot data sets. So how is a data set treated? Because a database has the data, but it also uses a very specific type of software to structure this data. So
there are in the database directive and in our law, there are specific requirements for a certain data set, let's call it, to be a database, legally speaking. And here again, it's preferable if you have access to a legal officer who can advise you on this, because it also depends. There's case law on the EU level that makes a distinction between data that has been gathered in different ways. In some cases it does form a database, in others it doesn't. And this is also case law that is evolving because of new technologies. So unfortunately I cannot give you the whole picture with details. I really would recommend again, every time you need this kind of legal certainty, to consult every specific case, which is a problem because most institutions don't have the resources to consult every type of activity with a lawyer. Yeah.
That's the huge problem.
It's a huge problem. Even the legal officers that we have within the institutions, they are mainly dealing with employment law and not really with IP law or IT law or so on. So this is something that has to be considered. I mean, even when we are talking about funding of these types of activities, legal compliance is something that has to be considered as well. I think it's very important. Also, preferably considered beforehand and not after the project is done, and then it turns out that probably all been in this situation when the lawyer consults after the fact, and usually it turns out that it's not legally sound. All the work that has been done was not legally sound, and it's a problem. Okay, so patents. When talking about data, data can be part of a patentable invention, in which case we have to be really careful with sharing this data, because this can damage the patentability of the invention. This is why open data rules do not force the researcher by default to share the data and to open the data. It really does depend, and usually open data rules apply to data that is already public, so made public in any way. The main focus is to not let data remain behind a paywall. But it does not, as a rule, force the scientists to share the data under any circumstances, because these data can be sensible, can be part of a patentable invention, and so on.
Can I ask
Of course.
one question? It was situation from last few weeks about research for patenting. What's about sharing metadata? Because I have two different legal opinions, really. That if you are going to patent your research, you can't share anything, even metadata. But on the other hand, I have a second legal opinion that you can share metadata, and you can put the data set into the repository under restricted access. I can show you the example after the break from my repository. So you have open the metadata. However, the data set, data container is under restricted access with the message that it couldn't be shared in open way because of the patenting case. So what's your opinion?
Well,
for metadata and...
A disclaimer once more, I'm not a patent attorney, so this sounds fairly specific. It depends whether or not the metadata is somehow part of your invention.
Okay.
And it depends if it's public or not. I mean, if it's shared amongst colleagues, then it's obviously not public. If it's shared with the wider audience, that this might damage the patentability. Yes.
Mm-hmm.
I have a different opinion about the metadata. Of course, I'm not a specialist in this, but the metadata is not directly developed data, it's indirect data. So how can we have any claims on something that does not depend on us?
Okay, so metadata in most cases is not copyrightable, probably, but it can be. I don't know, for instance, with cultural heritage, if you have some kind of annotations, it can be copyrightable.
Yes,
then
fields, so
it depends.
On the field.
Then it can be protected as a database under the sui generis database right, because there you don't need originality. related rights are not linked to originality because we are not talking about copyrights, but about specific investor rights, let's say. So they don't care, these type of rights don't care about originality. So it's a way to circumvent basic copyright rules in this respect. So I just want to mention trade secrets. Trade secrets, this is not part of intellectual property rights stricto sensu, but sometimes it's considered a type of intellectual property. I mean, it is an intellectual asset of the institution. And some types of information can be only protected by a trade secret. Because it's not copyrightable, it's not patentable, and there is also a legal framework for sharing trade secrets amongst partners, for instance, consortium partners and so on. And they're the main legal tool that we have to rule the sharing, the use of these data are NDA, so non-disclosure agreements. Just briefly touching on this. Now, I want to focus more on copyright because licensing, which is very important when we are sharing data and using data, is a copyright tool. So I would like to focus a bit on that. We already mentioned that copyright protection arises automatically. It has a term, although it's a very long term of protection. In most cases, we have 70 years after the death of the author. The last author, if we are talking about co-authors. So in the cases when we are already dealing with copyrighted subject matter, like for instance with cultural heritage, digitization and so on, we have to clear the rights, and we have to keep in mind that it's a very complicated process because we have different authors, different length of their lifespan, so it's a very complicated task to clear the rights over a collection, for instance. There are, of course, there are mechanisms to use these works, especially by cultural heritage institutions, also universities, academic libraries, and so on. But it depends on the case. So, what does copyright represent? The author or the rights holder, if the rights were transferred in some way or already licensed, holds the rights and has some kind of monopoly over the use. So the author can authorize the use and can prohibit the use. How does the author authorize the use? Mainly by licensing. So this is something that is fairly obvious, and I'm apologize to everyone who is aware of this, but this is something that gets confused very often. Licenses are tools by which the author gives the rights to someone else. This is not a tool to protect the work, because people kind of make connection between licenses and patents and often think that by licensing we are protecting the work. People are attaching Creative Commons non-commercial licensing, thinking that they are prohibiting the commercial use, but what they are in fact doing is authorizing the non-commercial use that was prohibited in the first place. So we said that copyright arises automatically. So if you see something copyrightable, it has the full set of rights. It's all rights reserved. This is the situation. And then if the author or the rights holders wants to authorize some kind of use, they will do it by way of license. Okay. So the license is a contract. It's a contract by which we authorize use. And of course, contracts can be individual contracts. This kind of use can be organized by collective management. This is the case of broadcasting, over radio, over television, and so on. And it can, of course, happen with standard agreements. like agreements of adhesion, like end-user license agreements, when we're talking about software, terms and conditions, when we are dealing with platforms, for instance, or different services. And of course, we have standard public licenses, like for instance, software, we have licensing in software, standard licensing in software, different types of licenses. Creative Commons are standard public licenses, the most popular, I would say. We also have specific licenses for data sharing, but still I think that Creative Commons are the most common licenses. They are used mainly to share digital content, but these are the licenses that are routinely used by the European Commission, by Horizon Europe, so these are the most common licenses. And of course, we have open licenses. Not all standard public licenses are open licenses. And for instance, the Creative Commons licenses, which I'm just going to skim over next, we have 6 licenses. 2 of them are open and 4 of them are not open. So we have to think about that. Here are the Creative Commons licenses. I think you are all familiar with them. Just very briefly, we have these 4 elements. Can I use the mouse to point? Okay, so first element is attribution. And you will see that all 6 Creative Commons licenses have this requirement. Why? Because when something is copyrighted, the author can never waive their authorship rights under legislation. Of course, we have CC0, which is not a license. It's considered a tool to just waive all your rights. This is something that is possible with related rights, if we have some kind of related rights over a database, but it's not possible, especially in Europe, over copyrighted works. The author always remains the author. They can license all their economic rights, but they always remain the author, have to be quoted, cited. Then we have the non-commercial clause. If we have this non-commercial clause, then the data set or the content cannot be used for commercial purposes. We have the share-alike clause. This is the copyleft clause. Have you heard about copyleft? This is a concept in open source software. Copyleft is, as you can see, it's a wordplay, the opposite of copyright. So this is the case where we attach a license to the data that makes it impossible to close it in further, when dealing further with it. For instance, the GPL, GNU public license, the most common software license, is a copyleft license. It does not, it actually attaches the copyleft element every time that you somehow adapt software under this license and you share your adaptation, it has to be under the same license. Just to mention, which ones are the open licenses here? The ones that do not in any way impede certain types of use afterwards. So the only open licenses are CC BY, which allow for free use of the content, as long as we cite the author, and CC BY share alike. This means that we allow all types of uses, but we oblige the user to further the same licensing conditions. All the others are not open because they in some way limit the use to only non-commercial use, to only use it as is without adaptations and so on. So these are not open licenses. If in your project you have a condition to publish under an open license, you can use the first 2 but not the others. Okay, privacy framework, very briefly. Okay, so here we have the term data processing. It's not about somehow having hold on this data or buying this data or acquiring this data. We have rules to process data. We have conditions to process data. We cannot own this data. or sell it. So handling data, personal data in any way constitute processing. It's not only about communication to the public. So if we are not sharing the data set but still somehow working with this data, especially if there's automatic profiling of some sort involved, it's data processing, okay? And it requires certain conditions to be met. We have grounds for lawful data processing. Consent is one of them, but not the only one. So either we require consent from the data subject, or we also have other grounds to process data. Consent is not the only one. There are, I think, 10-ish grounds for data processing. I'm looking at the colleague because I know he's an expert in this. You might process information because of contractual or legal obligation or public interest, and of course we have legitimate interest. So there's a legal ground for data processing without the consent of the data subject, but we have to meet certain conditions to do that. There are also rights of the data subjects. They can, in different cases, depending on the grounds for processing, they can require transparency, access to the information you have about them, and also the right to be forgotten. Then they can require for you to remove the data. Thank you. And then there are safeguards in the specific legislation for lawful data processing, like you have the rules data protection by design and by default, data minimization. In some cases, processors have to do impact assessments, they have certain liability, and so on. So just to recap, we have certain rules to process personal data. It doesn't, we don't have, like in intellectual property, certain point where we said, okay, we already acquired and cleared the data and we can do with it whatever we want or whatever the license allows. No, we have to follow the legislation the whole time while we process the data. And now just briefly, and I think that's the final one, open data framework. Now, open data in general is more subject to soft law, so not to legislation, but we have some legislation regarding open data. What is very important here is that we have open data requirements whenever we have public funding involved in some way. It depends. Different national legislation have different requirements regarding the percentage of public data and so on. In Bulgaria, we don't have a certain percentage. As long as we have some public funding, there are certain requirements to opening data up. And another thing I might add, I already mentioned this, open data requirements do not equate forced sharing of data. It's just, its purpose is not to allow data being closed behind a paywall, let's say. In order for the data to be open, we have to meet legal requirements and technical requirements. So legal requirements, that would mean we have to use an open license on open data. In case there's something copyrightable in the data set, there has to be an open license attached. And then technically open, there are people that can talk more about this than me, I'm sure. It has to be compliant with the FAIR principle. So the data has to be findable, accessible, interoperable, and reusable. So just to recap, in terms of intellectual property, data can be copyright protected, either as some individual objects when we have for instance, images in the data set or something that is copyrightable. It can be also protected as a database as long as it's original. It can also be protected by a sui generis database right when there's a specific investment in the database. What does that mean for us? If we are the user in this scenario, we have to clear the rights. If we are the rights holder, then we have to use a license to open the data. In terms of personal data, it is protected by default, cannot be licensed, and certain rules have to be observed at all the time when we're dealing with personal data. And finally, open data is linked to public funding, and it has, by the way, limited application regarding research data. Just to clarify, the open data legislation is primarily focused on government data, let's say. It has some recuperation regarding research data, but it has another focus entirely. So when we're talking about research data, there are different legal frameworks that apply in different situations. We don't have a legal framework specifically designed for research data and for research results.
In